High in the misty mountains of Kanchanaburi province, a remote rural community has received national attention for putting environmental legal reform in Thailand to the test and emerging victorious. But their success came at a heavy price. Sompong Tongpachalai and Kamtorn Srisuwan Mala are among dozens of people living near to Clitty Creek who became chronically ill after a mining company discharged high levels of lead into their drinking water supply in the late 1990s. Some in their community have died. Community members sued for damages, but after a legal battle that dragged on for years, emerged with negligible compensation. Then in 2008, the newly established Environmental Division of the Appeals Court, or Green Bench, reversed the trial court decision and dramatically increased their compensation, which was unprecedented in Thailand.
The
creation of environmental benches in Thailand resulted from an initiative by the Asian Environmental Compliance and Enforcement Network, AECEN, which was established in 2005 by a group of Asian countries committed to working together to strengthen enforcement of environmental laws. Although most Asian countries had legal frameworks in place, enforcement of these laws had been ineffective, which led to rising pollution levels and damage to the environment and human health.
Many of the environmental ministries in Asia do not have judicial powers. And that's why it was very important to green the judiciary, have them understand the importance of taking care of the environment as well as the particularity of environmental cases.
India has led the greening of the judiciary in Asia, setting up green benches at the highest levels. India's become a role model on environmental adjudication, and in line with AECEN's philosophy, shared its approaches with other Asian courts that are trying to improve their own systems.
They discuss and talk, then the issues become much more clearer, and the methodology to adopt by learning from the experience of other countries becomes far more greater and cohesive.
Thailand's Supreme Court adapted some of India's policies and procedures to set up its own green benches, separate divisions of the Supreme and Appellate Courts, which resulted in the landmark Clitty Creek ruling. The Philippines went further, establishing more than 100 environmental courts following observational programs to India, Thailand and Australia.
Certainly our experience has been enriched by the best practices in other countries. For instance, before setting up these green courts, we did visit Australia and observed how the green courts there are functioning.
Australian Justice Brian Preston heads the New South Wales Land and Environment Court in Sydney, the oldest environmental court in the world. He's an active participant in AECEN-backed training opportunities, twinning partnerships and mentoring programs led by more established courts like his own.
I think it has a responsibility to share that knowledge with other courts and to improve the capacity of other courts, particularly in the Asian region, in environmental adjudication.
AECEN has been instrumental in elevating the rule of law and creating platforms for direct engagement on environmental issues.
It has been a win-win situation. The progress in complying with and enforcing environmental laws in Asia with AECEN assistance and twinning program has been remarkable.
These ongoing judicial reforms have led to more effective enforcement of laws protecting Asia's fragile environments by punishing polluters and ensuring that victims can make their voices heard and receive adequate compensation. There's a long way to go, but cooperation, partnerships and exchanges under AECEN have begun steering many Asian countries away from environmental disaster and towards a path of sustainability.